categories of law. So we had our sources of law, now we have categories of law, and we break them up into private and public. So they might also call private law tort law or civil law. Do you guys know what the word tort means? Wrongdoing, exactly. It means wrongdoing. So the tort, sort of, when somebody starts a tort action or sues you or starts an action against you under tort law, tort is just kind of like a hodgepodge category where it doesn't really fit anywhere else. So that's the reason why it's with the private law, because the private law stuff is regarding individuals. So two people, a person in a company, or two companies. Okay, so in that case, it's just the general population, whether it be company or private citizen. For public law, this is the stuff that is the government is concerned with. So state, problems between a state and the individual. So there are three different parts of the law that the government cares about: tax law, constitutional law, and criminal law. Does the government care if you pay your taxes? Yeah, the government always wants their money, right? They do care. Do they care if you violate other people's constitutional rights? Absolutely. And do they care if you beat somebody up? I hope so, right? So these are the only three places where you're going to get the government involved for the purposes of the exam. I know real life is a lot more complicated. Anything else, so when we're talking about contract law, agency law, divorces, just regular old torts where we can't even put it into a specific piece of law, anything else, problems between individuals, is all going to be in that private law category, okay? So as long as you remember those three and know that public law is government, you're good for this slide, okay? You're good for all this information. Now, I always got these mixed up, and I could never keep the government straight. I never remembered which one the government was actually related to. I always, it was hit or miss whether I get it right. So what I thought of eventually was, so you may disagree with this, but what is supposed to be the government's duty to do? What is their job, their primary job? To protect the public. So there you go, public law. If you remember that the government's job is to protect the public, then you'll remember that the category they're concerned about is public law. Is that helpful? Hopefully, yeah. Well, it was for me because I could never keep it straight, so. Okay, these are two really simple questions that you might get. They could switch it and they could ask you about private law as well, which means you'll have a different list of answers, okay? So which of the following falls within the category of law called public law? Three. And you say three because public law is who? Is government. So government cares about constitutional law, so public is the government, right? It's their first duty to protect the public. Which one of the following does not fall within the body of public law? Agency. Public law, we're talking government. What does the government care about? Taxes, criminal, and constitution, but they don't care about agency law. Is that easy? When you know what you're supposed to know, it's pretty easy. If you don't, well, that's when it becomes a problem. Where a case is brought before the judge of the BC Supreme Court, so they're going to ask you sort of finish this sentence. So the judge may exercise only equitable jurisdiction in deciding the matter. What do you guys think? I have some heads saying no. What is the danger word in that sentence there? Only, yeah, so UBC loves to give all-encompassing absolute statements. So all must be never, none, always. Those are the big five. If you see all must be never, none, always, more than likely that is going to be a false statement that they've given you. There are some other words that sometimes can be included in that, and only is one of them. So it's saying the judge can only choose from equitable law to base his decision. And we know that's not true because we know there's the common in the statute as well. The judge may exercise both equitable and common law jurisdiction in deciding the matter. True or false? True. Some people may think it's false. I have some people say, well, it sounds to me like it was what we were just talking about. They're saying that the judge can award damages and can award a specific performance at the same time. And I want to say this is not my favorite answer choice. This is UBC being jerks, okay? What they're suggesting with this one is they have a choice. It's not suggesting they're going to use both of them at the same time for a single decision. It's saying they have a choice between the equitable and the common law, and they have their option to choose whichever one. So I know it's not worded very nicely, it's not worded very well. That's the reason why we do it in class, so that you kind of get a heads up for that, okay? Where common law and equity conflict, the judge must apply the common law rule. No, what one would the judge choose over the other? Equitable, the equity, and the judge may not do any of the above. So remember I was saying that this one looked like a bad choice. This is our answer, right? This is a true statement we decided. This one looked like it might have been a bad choice because it might be false if you're thinking that he's applying both at the same time. So a lot of times people will get suckered into choosing answer number 4 with that one. Okay, I know this is not nice because I see some looks on the faces out in the audience there, but it's the reason why we do it in class. Which of the following statements concerning the equitable jurisdiction of the court are true? So the rules of equity were developed as a remedy for the rigidity of the common law in England. That's a reasonable statement, yes. So when you see that and we're looking for true, can we knock anything off the list? 2 doesn't have a in it, so we can automatically say that's not the answer. What about B? Where the rules of equity and common law conflict, the court will apply the common law rule. False. So anything that includes B can't be the answer, so what is the answer? 3, because B is in 1, 2, and 4, so we know automatically that A is the answer. But again, when you're practicing, you should be looking at all the answer choices. So equitable remedies are available to parties in a court action as of a right, regardless of their conduct. What do you guys think of that statement? Are you always guaranteed remedies in a court? Do you think you might have done some things wrong in a situation that might be proven, that might make the judge not want to award anything to anybody because you're both dumb and you're wasting my time, right? So you can have all different kinds of situations. So again, this I would put in that all-encompassing type thinking where you're always entitled to a remedy. That when you rephrase it like that, you see that that's probably not a reasonable statement. Specific performance, injunctions, and legal damages are 3 types of equitable remedies. What do you think? We know it's false. What's wrong with it?
Injunction.
Equitable. What's on the equitable list? Specific performance?
Yeah.
Injunction?
Quantum.
Quantum merit. So what is this from? Common law. So this is a perfect example as to why you need to know the remedies for each of the common and equitable law sources, and you have to keep them separated. You can't get them all jumbled up, okay? And they come up to haunt you quite a bit in some of the other chapters.